Hi, and welcome to the Mission Motherhood Show. I am so excited for this episode today. By the way, the show is brought to you by my nonprofit, Cheri's Choice, and I am your host, Cheri Bergeron. Each week, we go into the challenges that modern women face going through relationships, navigating infertility, and figuring out their path to motherhood on their own terms. And today, I have one of my favorite people on the show. It's
Aw.
it's true, James Evans, which he goes by Jimmy. And it may surprise you that Jimmy is also a divorce attorney, but one of my good friends, good trusted friends. And so it may sound strange to you to have that kind of affection for your divorce attorney. And I did some research on this, Jimmy, and it's actually like less than 10% of people
Oh yeah.
consider their attorneys to be their friends. But I think it'll make sense once you hear a little bit more about the story and the journey that we went through. So, but first, let me tell you a little bit about Jimmy. Jimmy is a board certified family law attorney and the founder of Evans Family Law Group here in Texas. And he has 25 years of experience and has really built a reputation as a trusted advocate, and particularly specializing in high conflict cases, really some of the more complex cases. And Jimmy has been named Texas Monthly Super Lawyers for the last 10 years, starting in 2015, and is named by Martindale as one of the top lawyers in Texas. Now, I did not necessarily know that going in, that I was in such good hands, but I will tell you, I was in a desperate situation when we first chatted, and we'll get into it. But
Okay.
thank you so much for coming on the show.
Well, of course. I'm happy to be here.
Yeah. And there's so much that women need to know about this topic. And I know you've been doing this for a long time and you are super busy at what you do representing clients. How many family law cases would you say that you have handled over the years?
Oh my gosh, thousands.
Thousands
Yeah,
and
easily
thousands.
thousands. Yeah.
Yeah. Yeah, I would say so. And you know, um, one of the things that I caution women about is sort of settling for Prince Convenient, as I call him in the book, because their biological clock is ticking. I mean, I know you don't always have visibility into that, but I mean, do you see that dynamic happening where, somebody kind of force fit a relationship, they have kids just because of that urgency, and then they find themselves in divorce court?
Yeah, sure. I mean, and a lot of times with pre-marriage agreements, that are very restrictive. But yeah, that's not that uncommon. And I call that the lull, where you get lulled into a situation where you think everything's just rosy, and typically a wife may become a stay-at-home mom, and things are going fine. You have kids, and life is good, but then we've given up that career, and we've given up that option to have that career. And it's a really tough call if the relationship's not working. It's awesome for families if that relationship works.
Yeah.
When it doesn't and divorce needs to happen, and especially if that mom is in a situation where there's a very restrictive pre-marriage agreement, that's a very difficult situation to be in.
Yeah, and frankly, a lot of the women that I talk to are sort of ambitious career women, like I am, who typically don't give up their career entirely, but certainly sometimes we step back because it's really hard to have it all. We'll talk about let's talk about that for a second.
I was
So
about to say, I mean, because look, I think traditional families, whether it's same sex or otherwise or whatever, it doesn't matter. But the traditional family of having somebody that is kind of that stay-at-home parent, I think that's really good for kids. I mean,
yeah,
that's how we did it with my kids. But at the same time, you've got to be cognizant if you're seeing signs that the relationship's not in where it needs to be, and you need to be thinking about just educating yourself about ways to protect yourself or have sort of a plan B just in case. If the relationship's awesome and things are working great, that's awesome. But
right.
there are options, and before you just kind of find yourself stuck in that situation.
Well, and ladies, I mean, I think we need to be honest with ourselves when we are trying to force a relationship along because we feel our biological clock's ticking. And I guess one of the things I want to say about that is sometimes doing that can really be a perilous thing to do, because if there isn't fundamental incompatibility, then you can often find that children aren't enough and the relationship ends up severing, and then that can cause a lot of problems. Whether or not you choose to give up your career or not, going in with a motivation of feeling like you have to do that to earn motherhood, I think is kind of a losing game from that perspective. But one of the
It
things
really
that,
just depends on the relationship, right? So,
yeah,
yeah,
well, mine was certainly like that. Mine was
yeah.
certainly like that. And um, one of the things that we talk about prenups, but there's also something called a postnup. And so, can you explain, what's good and bad about prenups and postnups?
Well, first of all, let's start at a high level. A post-marriage agreement is the same idea of a pre-marriage agreement, except it is what it says. It's post-marriage. In Texas, a pre-marriage agreement is designed to affect assets as you go into the marriage and control those assets, and most likely and most commonly the assets that you've accrued during the marriage. Like the most common version is no community or what we call marital or community property is ever created during the marriage. Everybody just has separate property interests, and if you're very intentional, you can jointly own things together. That's the most common version of a pre-marriage agreement. A post marriage agreement is a really good option for the situation we're describing, because you're not divorcing, but you're going into a situation where you're not exactly sure what's going to happen. And if you have some assets, and then we can take a post marriage agreement and structure an agreement so that the parties, men, women, wives, whatever, are secured financially, or more secure. Let's just say it that way, has some security,
Yeah.
that if this doesn't work out and I've elected to stay at home and be that home provider, home care provider, that if we do end up in divorce, if we do, then these assets I know are coming my way, or insurance, or some stream of payments. Now, these agreements by law cannot address the kids.
Right.
Like it can't order child support, it can't waive child support, it can't affect custody or primary custody and things like that. But it can create a post-marriage situation, and I've drafted many of them myself, where if someone's elected to give up a career, then in the event we have kids and they've elected to become a primary home care provider, and if there's divorce based on years of marriage or ages of the kids or whatever, then there are like contractual alimony payments, and we define those payments. That's just one example. But you can define payments like that, or streams of payments, or property that can be secured by you just in case the marriage doesn't work out. So that's an excellent
Yeah.
option, especially if there's some assets out there.
Right. And, a lot of people think that just when you get married, it's 50-50 and there's nothing you can do. I think there's not a lot of conversation about post-nup agreements, but the fact is that, you know, those can certainly demonstrate what the intentions were by both parties and really formalize some of those things that can ultimately protect you later. So, you know, so
Well, and it may seem weird, like, but these days, like, it's way more common, Cherie, for post-marriage agreement conversations to be coming up. And especially if you're a successful career person, woman, especially women, let's just call a spade a spade.
sure, sure.
And you're giving up that career, it's okay to have that conversation. It's going to be awkward, I get it, but it doesn't mean we're divorcing. And these days, this conversation, at least in my experience, it's more and more common. I mean, recently I did a post marriage agreement for a couple who had experienced the death of a child in the family, and they wanted to write some things to address certain kinds of assets to honor the legacy and the memory of that child, because that child was on a path to have a certain type of career, and they had already started building the business for that kiddo and stuff. And so but it's the same idea. Post marriage agreement. I would encourage your women who are watching and they're entering into motherhood and they've got a career of their own. And if there are some assets in the marriage, to at least have the discussion.
Yeah.
You can always say no, I don't, it's not worth it, how it's affecting our relationship and whatever. But if you guys are true partners in all of this, your spouse, even that's probably a test of the relationship to even have the conversation,
Yeah.
because
And
the
I,
idea is just to
yeah.
give you some security, going into that very life changing uh, event, that you're going to come out of that on the other side with some security. I mean, because let's, an elephant in the room or a spade calling it a spade, you don't have to honor that agreement. I mean, if life moves on and everything's rosy and great, we can revoke the agreement as if it never happened,
Yeah. Yeah. Well, and
So
by the way, one of the things I learned was it's always best to do an agreement when things are good and when
correct.
everybody agrees that this is the fair and equitable thing to do, as opposed to if things go bad and then, all history is sort of erased and everybody's on opposite sides, So I
Well,
think
and
it's
what you said is the key is once things are going bad, people are lawyering up. And
right.
these days, whether it's real lawyers or virtual lawyers through artificial intelligence and chat GPT, but once you get into that mind frame, reaching an agreement like that is very difficult.
Yeah, sure.
Yeah.
Absolutely. And this actually brings up an important point. I tried to avoid lawyers. I tried to avoid lawyers like the plague when we were splitting because I had this idea that two reasonable people could make agreements and that, we could write them ourselves and we were business partners, so I felt like we could make agreements and that they would stick. And I felt that also lawyering up, as you say, would sort of not keep things cordial anymore. But what, in your experience, why is it so important to have good legal counsel if you're going, if you've separated, if you're looking at going through support? Why is that an important call to make?
Well, because it doesn't mean that you're not reasonable people, and it doesn't mean that the reasonable people haven't come to adult-like reasonable decisions. But especially if there are assets or kids, it is very important to have someone who can help you draft the proper documents and, more importantly, the proper language.
Yes.
Because I countless times, especially early in my family law career, which is why I think I've become an expert in the drafting of stuff. Because early in my career, I had too many uh, ex-spouses come to me who did what you're describing. They all thought they did what they thought they were doing, but you sign it because you're trusting that other person. And even though, and then what happens though is you got to go back and enforce it, or that person changes their mind or whatever, and you want to go back to court and try to enforce it, and suddenly you look down and that language isn't there, or it's not written the way it should have been. And then you have no way to enforce what you thought was your agreement. It doesn't matter how reasonable or adult everybody was, things change post
Right.
divorce, right? And
Oh,
good fences make good neighbors, and that is the best phrase ever in family law, especially in divorce situations, because the better the draft, the more precise, then it just makes it so much easier for everybody to, to separate those assets and do it the right way. But more importantly, when that person meets their new person and now they're mad at you and they don't want to give you that money that you thought y'all had an agreement on, and because now that person looks, their new person looks at the agreement and goes, it's not in the order. And then now their new person's convinced your ex to not give you that money.
right.
And, so it's
Outside
very important.
influences, the level of good
Yeah.
faith, all of those kind of things. So in my case, let's get into a little bit of the nitty gritty of it. So in my case, my ex and I, or at that time, estranged husband, had actually we'd written an agreement where he relinquished the parental rights to our embryos because we were, at a fertility clinic and we had in the document that if in the event of divorce, I would get the embryos, but I wanted to move forward ahead of that. And so we wrote up our own document of kind of relinquishment of parental rights to those embryos, which he later changed his mind on. And that agreement did not would not hold up in court. In fact, it wasn't even mentioned in our case. And so why is that? An agreement like that, why would, my little self-drafting not work?
Um, well, because it's not. People do that all the time, and what I tell them is that it's evidence of what you guys wanted to do, but not all written documents have legally binding effect. And that's really the issue. There are only in family law certain written documents that have that legally binding effect. Otherwise, if you're not like a mediated settlement agreement, a court order, there's an exception if there that's called like a 6604 settlement agreement under certain circumstances. But anything else like that is basically either a contract or it's what we call by extension a Rule 11 agreement but they're subject to revocation,
Yeah.
or if they are enforceable, they're enforceable in the nature of contract and not by way of like a court order to be like, and then we end up fighting over what's the contract and, what are the terms, and you get into ambiguity and all that stuff, that comes in to challenge contracts.
Right.
So that's
No,
that's the answer.
absolutely.
Yeah.
And I think the other piece of that is when it comes to children or parental rights, that is where there's the big red flag. Like that's where it is so critically important because our courts really want parents to be involved in their children's life. And a lot of times they will, unless it is airtight, they will allow that parent to change their mind. Wouldn't you say that's true?
Yes.
Yeah. Like,
I don't know how else to answer that, but
yeah,
yes.
I mean, that is the biggest danger zone. And in fact, that's why he's saying that in advance, you cannot create agreements that are child custody agreements, child support agreements. That is the sort of holy grail area where you must work with an attorney.
Yeah, if you're,
So,
but that's the answer to, that's why our Constitution and the Family Code does not allow parents to enter into agreements like that around kids, especially at the embryos before they're even born. Because by law in Texas, they're not children until they're actually born, regardless of your beliefs or whatever, but that's the law. And, parents just can't enter into contracts that contract around custody or child support.
interesting
They're
because, fertility clinics do have you sign things. So that actually is something that then just gets debated because I've heard that that is being hotly debated in various courtrooms these days, who gets the embryos and that kind of thing.
Yeah, those types of agreements, typically the courts will honor them, like, but it just depends on the situation and if somebody's changing their mind,
Right.
this kind of a thing. So
Right.
that's
Well, in my
ultimately
case,
it's
he
up to
couldn't.
the judge.
Yeah. Yeah. Okay. Well, we'll get into that because, the subjectivity of the law in general, I think is really fascinating. But so in my case, I'll get selfish for a moment. We were talking about, in my case, so after I had my daughter and he changed his mind and wanted involvement, which, by the way, if a parent wants involvement with their child, I would never want to be the person who would prevent them from having a relationship with that parent. So that was always, I felt that I was misled by his intentions and signing that and all of that. In the end of the day, I would never try to keep him from my daughter. But so we were co-parenting my daughter, and then years later, after a legal separation, I decided to move forward, having a child on my own using an anonymous sperm donor. And, I know that my case threw you for a bit of a curveball around this. So what was so unusual about
Well, at which stage? I mean, and first
it?
of all, you're okay with me talking about this because
Yeah,
we do have
well, obviously,
attorney-client. I mean,
I wrote a book about it. I mean,
just
and you're
asking.
Sir Jimmy in the book too, by the way. Jimmy's character is so awesome in the book. It's all, I mean, it's true, but I love the way that you're characterized in this book as the white knight who comes on in his Jeep Rubicon with his border collie. So.
Okay, well, that's what happened. Um, so, I mean, let's just talk at a high level. You were in a situation, since you're okay with me discussing it. I mean, when I got your phone call initially and heard the situation about, your daughter and you guys were divorcing and he was the dad, and that you had gone and done IVF and he had waived his rights and didn't even participate in that process, wasn't even a biological participant contributor, and it was completely anonymous, and that's how you became pregnant with your son. To me, it was just a no-brainer. Like, well, why can't you just go get a paternity test? I mean, that just seems like a no-brainer.
Of course.
And so I was like, well, yeah, we'll just go get a paternity test and go figure, knock this one out. And it was just such a unique situation that I hadn't actually had to litigate that specific situation. And what we found ourselves in, as you well know, is that this was many years later. And, daughter and son, without you realizing what was happening, both kids were going with dad of daughter, and siblings were going together on these visitations.
With
And over
me, with
and
me,
but
not
well, we're not
independently,
going to
but
get
with
into
me.
all that, but I mean, just
Oh, we
over
are.
time, he changed his mind and wanted to be the dad of the dad that he had no biological contributor to. You guys had not been living together for years. There was no chance of conception, by sex or whatever. And he clearly was not the biological father. But we had this hanging Chad problem in the law because the law presumed that he was your son's father because y'all were married and because he was born during the marriage.
Right. Right.
So we, and the only way out of that, as I discovered under the family code, is a court ordered DNA paternity test. And there is a section in the family law code. I didn't go remind myself of it before this. I should have, but as you well know, that has all these various factors that the court can hear when they hear all the evidence to decide whether or not that paternity test should be ordered.
Right.
So it is possible in a case like yours, and it was possible. Everybody knew that he was not the dad. Everybody knew he was not the biological father. And the judge could have denied our request at that trial. And if had the judge denied that request, we would have had no choice but to have recognized him as the presumed father, and he would have been adjudicated as his dad.
Yeah.
And it would have been a terrible result under the law. And we've only barely touched the surface and scratched the surface of what was really happening with his relationship there. But
Right.
that's the situation we found ourselves in. And because it required a trial, then we had to deal with court dockets, court scheduling, discovery, and they of course were finding every possible way to delay having that trial as possible. And so it wasn't for lack of effort. We kept trying to get to have that trial, and of course, but it took a while. And to your credit, you were able to fund that because a lot of people couldn't have done that. They would have just had to give up,
Right.
and that would have just been a terrible, terrible result. And it would have caused him to just live a lie for the rest of his life. And as you know, that's ultimately why the judge denied the paternity and granted our request for that test, because he knew and he didn't want the child to live a lie.
Right. Right.
So
Exactly. And that, even that statement kind of gets some judges the hair on their neck stand up. They don't like that idea, because if somebody, sometimes the courts really feel like there should be two parents in a child's life. I think there was that sentiment that, hey, every child deserves a mother and a father. Do you think that that is really kind of baked into our system still?
yeah, I think so. I mean, because you couldn't go to a hearing before any of our judges, any of them, and that I practice in, and just say the dad shouldn't be involved, because he's the dad or whatever. I mean, I think the courts prefer, to find a way to have both parents involved. And everybody knows both parents bring different kinds of developmental kinds of skills and parenting skills and personality traits that definitely contribute to the development of that kiddo.
Right.
So
But the
yeah, no,
way
I
that
think so.
but see, here's the problem, because we start to have more modern ways of building families where, let's say, because I used an anonymous sperm donor, that put me in a unique place of risk, right? And why is that?
Well, let me address. I mean, because had y'all been divorced already, right? I think to go back and readdress that topic for a second. If you were just a single mom and went through that process, no, I don't think the courts would just presume that there needs to be a two-parent situation.
Right.
If a mom goes through IVF and anonymous donors, then theoretically and legally there should not be another parent out there. That hopefully you're not surprised by that. Your situation was because y'all were still married.
Right. And the fact was, though, because it was an anonymous sperm donor, I could not produce who that person
Yeah, that's
was, right?
true.
Because there are people who go and have affairs, and there's a child by another man, and it can be very readily disproved because it's like, hello, I am actually the father of that child, and I didn't have that option because
Yeah,
it
we
was an
can.
anonymous.
I'm sorry, I didn't mean to
No,
interrupt.
no,
But
no,
if
no.
we got into the weeds of that, there are some limitations there. But Texas does have what we call a paternity fraud statute that's designed to order testing some years later into the marriage where, oh, surprise, it
Yeah,
was
yeah.
actually the Amazon driver is the dad. But it's very limited. You have to meet very specific criteria. But um, does that answer your question?
But for me, I think the thing is that because I used an anonymous sperm donor, there wasn't a person I could point to and say, no, he's not the dad. That's the dad. And
Yeah,
that
that's
was a
true.
part of the issue.
Yeah,
Okay, well,
that's true.
so it took like 6 months for my case to be heard. And just to kind of get the audience up to speed, during that time, I had to surrender visitation for my 4-year-old to this man who, previous to that, yes, they were around each other, but there were no independent visits. He didn't go with my estranged husband. I did not approve for him to go with him. In fact, I even explained to my daughter that the reason he doesn't go is because he wasn't his father. So in the fertility world, we talk about being very open and transparent about those things at an age appropriate way from the beginning with the child so that there's no, why did you keep this from me and stuff like that. And so we had been doing that. So that was a part of what was particularly jarring, that it took that long. And during that time, my son had to go to counseling, and there were therapists that are actually brought in to weigh in on kind of what my 4-year-old was thinking and feeling, right? So why is that necessary to have that kind of expert weigh in on a with 4-year-old?
Well, necessary is probably the key qualifier, right? But the courts are because you got a little who's processing a lot of stuff. And I mean, that's the real answer is, and you need somebody who's qualified and knows how to do the right kind of play therapy or do the right kind of therapy at that age, because that's a lot to process, and he wasn't making it easy, um,
Right.
but I mean, your audience needs to understand that because you were in such a unique situation with the presumption of paternity, you were forced by the judge to have sibling visitations, and
Yes.
because the judge was on an interim basis requiring us, because he was the presumed father, to have siblings go together on these visits. And that's what was so maddening, because we didn't have a process in the family code, a motion, a path to like fast track and show the court that he was not the biological father. This was an anonymous donor. None of the presumptions of paternity under the family code otherwise but for marriage apply it in your situation. And had we had that option in the family code, we could have just gone and knocked that out, and that would have never happened.
Right. Right. So and even there's an amicus attorney when you're of a certain age. An amicus attorney has to be appointed for this. And the amicus attorney can maybe just mention, why is an amicus attorney needed?
Well, I don't think in that situation it's required. I think the court did it in that situation
In law, I
because
think it was. By law
because
at 4, I think it was.
yeah, I can't remember, to be honest with you, but
Yeah.
but normally the reason for that is because an amicus attorney by definition is an extension of the arm of the court, and specifically by law is supposed to look out for the best interests of that child, and get that back and communicate that back to the court. It's a little bit different than a guardian ad litem, because an amicus is an attorney, and the amicus is somebody that can actually participate in the case and represent the child, and has more power, if you will, because they typically, it's a lawyer, and they can actually file motions, they can actually ask questions at the hearing. And until the law recently changed, they were allowed to give reports to the court, which was basically free form testimony. And
But
there
not
was
under
no,
oath.
not
But not.
under oath, and not subject to cross examination.
Right.
And that was maddening in your case that that happened, you know. But
Absolutely.
that's why typically an amicus is appointed.
So in my situation, there were so many other people that got to weigh in on the legitimacy of my family and who should be play the roles in my family, a therapist, an attorney for my son. And so I really felt very marginalized as a mother in that case, because there were all of these other people, even though I had pursued an independent pregnancy. And by the way, there was a legal expert that was brought in that argued whether I had the right to pursue an independent pregnancy as a legally married woman. You remember that?
Do you want to talk about that?
Well, I just want to talk about it briefly. We're not gonna name names, but I mean, just that the fact that that was a debate, right? That there was a woman actually who came
Yeah.
in and argued that I did not have the legal right, even though he was in another relationship, even though he wasn't the father, biological
Y'all
father.
been
But
separated for, not only that, but if people need to understand, y'all have been separated for years.
7 years,
I was,
7 years,
and y'all had already like done your agreements, like your divorce was all but done.
right?
And anybody could have and should have just stepped in and picked that up and just finalized it. So it wasn't like you were, I mean, like still kind of thinking about reconciling or whatever. I mean, you guys were all but done and living apart, completely separate lives. He actually had another romantic person that he was with for a
Yep,
couple years by that point.
the entire
And
time.
so so y'all were living entirely separate lives.
Yeah.
You
Well, let's
just
talk
had the
about
hanging
that.
chad that y'all were still married, and that's what caused the problem.
Right, right, exactly. And so that is a little tidbit, ladies, that, sometimes you may think, oh, I don't want to, I'm living life on my terms. I don't want to go through the hassle of that. I don't want to go through the expense of it. There's something that was benefiting you in that kind of situation. Like, for example, we had a business that we were continuing to operate. I was a single mother by choice. And so he was handling a lot of the business. And so I just kind of kicked that can down the road and procrastinated getting that done. And then also it didn't help. He couldn't keep to any agreements, right? It was constantly changing and that sort of thing. And so that's really what in our case created this prolonged issue. But I will just say it's not good to kick that can down the road. If you are intending to get a divorce, it does not help you to stay in limbo for years and years and years. And I think some families do fall into that pitfall. Um, but
Well, but if you're going to do that, right? Like sometimes it's by design, for health insurance or medical
right,
reasons
right.
or social security or something. That's when you do a very carefully drafted post-marriage agreement.
Gotcha.
And because that's where y'all were different. Y'all didn't draft one of those. You drafted a settlement agreement, but it wasn't ever taken to the courts for enforcement. So it wasn't official the way you needed it to be retroactive to
Right.
those 7 years before. So that goes back to why you need someone, who's an expert in all that. Because look, it could be I've seen people who want to stay partners and stay married. They just don't want to live together and they want to go live their separate lives, but stay married for different reasons. Maybe it's for estate planning or health insurance or whatever. But that's when you want two things, to be honest with you. You want a carefully drafted post marriage agreement so that all your stuff is divorced, like actually partitioned by law.
Right.
And two, you want a carefully drafted estate plan because those two things complement the other.
Yeah.
And you want to make sure your partner in that situation, however y'all are addressing it, but if you are intended to be the beneficiary of some of that estate planning, get that done and make that part of your post marriage agreement by contractual terms,
Sure.
and incorporate all that into the agreement.
I mean, it's so much more complicated than we as lay people can do. And by the way, an AI lawyer is not going to be able to help you with these complexities. I just want to mention that. There's one word that I really learned the power of. It's the word irrevocable.
Hmm.
And there's a lot of very specific language and magic words that attorneys know to put into agreements that make them truly be binding. And you don't want to miss out on that because you need somebody who really understands those things. So we mentioned that judges actually have a fair amount of discretion in custody cases. So, there's the law, and we as lay people kind of think, well, the law is the law, and it's binary. It's either in the law or it's not in the law. But really, what I learned is there's so much interpretation. There can be subjectivity, and then judges are human beings too. And so, what sometimes we think the law is very straightforward, but it isn't always that way. Can you talk about that a little bit?
Yeah, well, at a high level, and I think most people know that, the standard in custody situations is almost always driven by, quote, the best interests of the child. And therein lies the subjectivity, because what does that mean? I mean, our law does have what we call the Holly factors in Texas, and there are specific factors that fall underneath that to help determine, and guide the court as to what's in the, quote, child's best interest. But at the end of the day, if the best interest is to call an apple a watermelon, the judge is going to do that, and the watermelon in by court order becomes an apple. And and because the courts have a lot of discretion in informing custody agreements in terms of conservatorship or custody visitation inside of that best interest standard. Things like child support are a little bit more formulaic and
Right.
driven by numbers and actual needs of kids, like special needs kids versus non-special needs kids, private school, public school, whatever. That's a little bit more black and white. There are still some gray areas there, but it's a little bit more black and white. But the best interest standard is what gives that judge so much discretion.
Absolutely. And who decides what is truly best interest? And that's where it's really important to have someone who really understands legal strategy and strategy around custody disputes, I think. So, I think you were particularly exceptional in that. You and your firm were particularly exceptional, but it surprised me a bit that that was the case. And it seems that my case is a bit fringe, but I will tell you that every state in our country has presumed father laws, and some have more strict presumed father laws than others. For example, Texas has this case where you can deny a DNA test. Other states, and I've looked into this a bit, and I know you're only licensed in Texas, so we're only going
Right.
to start talk about that. But California and other states, Washington and Colorado, have things called a psychological father or an equitable parent and things like that. And so it's so important to look into the laws of your state, because there is the possibility, and this is why we had to go through this long trial, that if it would be detrimental to the child to remove that parent-child bond that the court perceives, that is when the court can try to protect that bond for the betterment of the child, if that's the way that they perceive it, right?
Yeah,
Yeah.
that's true.
So how do you feel that those laws need to be changed? Because in some ways, and in my case, we weren't trying to be a family. I wasn't holding him out as my
Right.
son's father, all of those kinds of things. And yet it was kind of like a loophole in the law, if you will, that sort of didn't. I know our laws talk about fertility, they do address IVF and things like that, but
Hmm.
perhaps not fully the way that families are formed these days, and that we stayed married while I was pursuing motherhood on my own. What do you think? And I know we're going to be working on this, but let's just talk for a moment about how those laws might need to be changed to better protect women in that case.
Yeah, and that is a key distinction in your case, because the psychological fathers, if you will, or equitable parenting. I mean, Texas does have a concept known as equitable adoption. And it can happen, but it's typically in a situation, and almost exclusively in a situation where the other person who's not the parent is being held out as the parent. And it's typically after a period of years, like an 11-year-old child has been held out, with the step parent as the parent, and they never knew any different, like that child's entire life. And it's just the right thing to do to leave that in place. I mean, that's the way to say it. And that's why judges view, in situations like equitable or psychological adoptions kind of a thing. But the law in Texas, the problem you had was you weren't holding out, and everybody knew the situation. You just had this presumption of paternity problem, and we just could not get around it. And it allowed him to have the standing to seek court orders of temporary access and conservatorship over a child that clearly was not his. You were not holding him out to be the dad. In deposition, he knew he admitted he wasn't the dad. So the law in Texas needs to have a change in the family code so that when a situation such as yours, which is very unique, it wouldn't happen very often, but when it does, and it's so clear that we weren't living together during the time of conception, we weren't having sex or cohabitating during the time of conception, that if it's an IVF and not a sexual conception, right, that person didn't participate, or they signed the waivers, or that it's an anonymous donor. It shouldn't matter that that those folks are married. There should be a fast track path to the court to get that DNA, or to deny it altogether, especially if there's siblings involved, because that would have saved so much time, money, stress, amicus, therapists, and it would have never put your son through that.
Right. Right.
But there's no
Absolutely.
legal motion. There's nothing in the family code that allows a fast track or expedited hearing in a very unique situation like that. And all of those things that I just said could have been easily proven. And you and I were talking the other day, because the law could be similar to like an application for a protective order. In Texas, that's given expedited preference. I mean, the courts
Right.
have to, whenever there's 10 cases on the docket, and the 10th one is an application for a protective order, they have to put that to number one. They have to give that top priority. So in a situation like this one, where it's so specific, and checks those boxes, then it should be similar. It should be a situation where a mom, probably the mom, should be able to file a motion and have it heard on an expedited basis.
Right. And this is one of the things that through Cherie's choice, I want to work on that and work with you and help get the laws changed. But there is a website about that case, because some people think I'm making this up, honestly. They're like, this can't be possible, because it's surreal, right? And so there actually
I didn't
is.
even know you had that. I need to go. I need to go look at that.
Well, you're all over it. Yeah. And so, because I wanted this information out there, I wanted it to be freely available for people to understand this kind of process. So we may not have a lot of time to talk about this. We may need to have a whole nother show about. My case also had the issue of parent alienation. And, I'm wondering,
Mm,
this is a situation where one parent accuses the other of sort of poisoning the mind of the child, or doing things deliberately to sort of hamper or hinder the relationship and the affection with the other parent. I know this is a whole loaded issue, but
yeah.
is this typically something made against mothers? I mean, is it more often made against mothers, or is that just sort of my interpretation?
Well, in my experience, it's more often alleged against mothers than dads, but it does go both ways. But that what you described is not technically the definition of
Well, see,
alienation.
I'm not a lawyer. I'm not a lawyer.
Well, I've become an expert in alienation just through
Yeah.
litigation, but what you've described is the effect of it, like what you feel is alienation, but that's not the technical definition of it. But that you're right, that's a whole different show, and we could bring another expert on if you wanted to talk about that. But in my experience, it's more often alleged against mothers.
Yeah. Do you feel that, I mean, it's sometimes alienation is very valid. Oh, we'll do another show on it. But um, in my case, I kind of felt like it was a weapon that was being used. Are you seeing, and it ultimately did not hold up as having any kind of validity. Do you see alienation being a weaponized issue
Oh
in
yeah, well
cases?
yes, yeah. We need to do a whole hour on a different topic, a different show, if you really want to dive into
Yeah.
alienation and talk about it, because it's a describing what it is, probably better stated what it isn't.
Yeah.
But the biggest issue with alienation is one, identifying it, and as early as you possibly can, and how to and when to address that to try to start reversing it. A friend of mine, Loretta Mace, who's also an expert in this category, wrote a book called Parenting the Alienated Child, and it just recently got published. And it's a guide to parents who are on both sides, who are alienating, but it's primarily written to the parent who has been what we call the target parent, who is being alienated, on and learning how to identify those symptoms, if you will, and the red flags that alienation is occurring, how to acquire a skill set as a parent, and how to address them, and basically in real time. It's a pretty powerful book.
Yeah, well, she's amazing, and yes, we'll have more conversation about that. In my case, though, what if you're being accused of alienation and it actually is not the case? So it's being used as a weapon. What
How do you
guidance do you
handle
have
that?
for yeah, how do you handle that?
Well, the preference is to get an expert, who is known. You don't have to, but the preference is to have a known expert who can come in and essentially do a reverse alienation assessment. To as if you were a doctor, just going down the checklist of symptoms and actually rule it out.
Yeah.
Because alienation has gotten to a point where it's so evidence based, it's almost down to like a science, and it's been studied so much and written about so much. There's so much expert material. It's no longer just hokey pokey alienation. Whoa, what is that? I mean, it's very down to, this is what it is. We know what the signs are. We know what the factors are, and we know how to address it. So, in a case like yours, what's really important is ideally, is to bring that expert in and officially rule it out.
Yeah. Yeah. And
And
And we didn't end up doing what we ended up doing is I actually went to go and see her because I wanted to know what for one, obviously because of my son, I was angry, right? I was incredibly angry, and that was something we really had to try to figure out because the courts
putting it
don't like.
mildly.
Huh? Well, I called myself a three-headed hydra in the book, I think, actually, because it was like that maternal instinct, and you have somebody who's harming your child. Ladies, you know what you would do in that situation. But I will tell you that when you're really angry as a spouse, it is really important to get some guidance about how to support your child through that, and how to keep your own emotions kind of as dispassionate about that, and allow the child to continue to have a relationship with that parent, even if they have hurt you, even if they have betrayed you. And I will tell you that I felt all of those emotions, and Loretta really helped me through, sort through some of that and show me how not, I was not an alienator, but show me how to be supportive for my daughter, which is sort of what can I do to really be supportive of her. And that was incredibly helpful.
Well, and you've hit on one of my favorite core topics a while ago, and it really applies here, because
Yes.
strategy. Because at the end of the day, it's not Chat GPT that's deciding the custody of your kids, it's a judge. And all those emotions are very real. Trust me, I saw them, right? We experienced them. But to
Yes.
your credit, you listened and you followed strategy. And
Yeah.
at the end of the day, you've got to remember, as maddening as that other parent can be, that all of your communications, if you are going to be read by a judge, and it's the judge ultimately that you have to be playing to, you 6, 7, 8 months later. And so everything that, even though you're experiencing all those emotions, and rightfully so, you've got to operate and communicate, respond, and act in accordance and inside of a very carefully structured strategy.
Yep. That's absolutely true. And I will tell you, and I know you have blog posts about this and you post on social media, but rage texting is a bad idea. I
Bad
just want to
idea.
let you know that through my process, every single thing that I wrote down, both good and bad, was paraded into court and put in front of me. So please always have that in mind. But Jimmy, one other question for you. What recommendations do you have for a woman who believes that her relationship is heading for divorce?
Get guidance and get good guidance. There's too many firms out there right now that, in my opinion, are driven by fees, and their associates are driven to develop strategy around their billing requirements and fees. And this firm, and there are other good firms. I mean, I'd be happy to name and share, because we all want you to get good representation. But the first step is to try to get a quality firm with a quality, advocate that can help sense like when you need to step in, when you need to act, and how, and develop that strategy, because that
Absolutely.
strategy could be long term. Maybe it's best for you to wait for a year. Maybe I can go through all kinds of reasons why that would be, so, or maybe you need to act immediately. And it just depends. But there's a lot of good advocates in the family law field. I think I'm one of them, that will do free consultations if you're looking to retain a lawyer. And so there's no reason not to do that,
Yep.
if you think your relationship is headed to divorce.
And you're one of the good ones in terms of not just legal capabilities, but just as a genuinely good human being. And so that's why I love calling you friend now. So I want to thank you so much for coming on, Jimmy, and for offering up your opinions on this and some guidance for women who are maybe before the process, during, or going through it right now. Be sure to check, everyone listening, Cheri's Choice, for other resources on how to navigate your path to motherhood, deal with infertility, and all of those challenges that we deal with. Again, I'm Cheri Bergeron, and I'll leave you with this. Remember, you can fulfill your dream of motherhood. I always say that with knowledge, determination, and a village that loves you, anything is possible. So until next time, thanks so much.
Bye. Thank you, Sheree.